Carpenter. I teach at the University of Minnesota Law School in the areas of constitutional law, the First Amendment, and sexual orientation and the law. I do want to thank the Institute and David in particular for bringing me to Harvard today. It is a great privilege and an honor to speak at this law school where so many important things have happened for the movement for equality for gay men and lesbians and for others who have been excluded and discriminated against in our society. I'm especially honored to have that wonderful introduction from Professor Ogletree. He is a powerful voice for equality. He has been for many years, and he continues to be. And I'm deeply grateful for what he had to say tonight about this book. What I'd like to do over the course of the next perhaps hour or so is basically present parts of the book on the assumption that you haven't had a chance to read every last page or word of the book. So talk about what's in the book a bit. And then I also want to leave time for questions that you might have, either based on things you've already read or things that occur to you that might be important. Lawrence versus Texas, the decision of the Supreme Court from 2003, struck down the Texas homosexual conduct law, a law that forbade oral and anal sex between two people of the same sex. It also struck down similar sodomy laws, as they were called, throughout the country, 13 in all, some of which applied to same-sex only conduct and some of which applied to opposite-sex conduct as well, at least on the face of the law. Although, in fact, in my view, they were used mostly to target gay men and lesbians in ways that I will speak about in just a bit. Lawrence is one of the most important constitutional individual rights or liberty decisions of the past half century. It's certainly on, I think, anyone's short list of important constitutional rights decisions. And it is the closest thing that we have yet from the Supreme Court to a Brown versus Board of Education for gay men and lesbians. Yet up to now, very little has been known about the background of this case. In part, I think that reflects an understandable, in some ways, desire on the part of lawyers, law students, and law professors to try to grasp the opinion by Justice Kennedy itself and try to tease out its potential implications. In part, that ignorance about the background was design. It was by design that little was known about what actually happened and about the men who were arrested in this case. This book is an attempt to bring some of that, as much of that history, that background story of the case to light as I could do. I'll tell you a bit about how it began, and then I'll tell you each of the background parts of the book. After the Supreme Court's decision in 2003, a case in which I had submitted an amicus brief for a group called the Republican Unity Coalition with a former clerk of Justice Thomas, I wanted to write a law review article for the Michigan Law Review, which had invited a contribution. And I had planned to write a fairly standard doctrinal law review article in which I would discuss each of the main constitutional arguments that was made in the case and talk about potential applications of these principles in the future. But before I got into all of that, following the standard formula of law review articles, I thought, well, I need to write a background section, just laying out some of the basic facts of this case. In part, I needed to write a long enough article with enough footnotes to justify myself as a scholar and get tenure at the law school, which I was still seeking at the time, and this is the way that you do it. But when I looked at the background of the case, I found out that we didn't actually know very much about what had happened. If you take a look, for example, at the Supreme Court's decision in Lawrence versus Texas, you see all of about a paragraph or maybe two, depending on how you count it, about the fact that police arrived at the apartment of John Lawrence in September 1998 in response to a reported weapons disturbance. When they entered the apartment, they found John Lawrence and Tyron Garner, they said, engaged in an act of impermissible sexual conduct with each other under the homosexual conduct law, and arrested them. And then the challenge to the law flowed from there. And I thought to myself, there must be something more interesting to this story than that. It can't have happened in just that way. There must be something more here. So just again, with the thought that I would write this background section to a law review article, I began calling around to friends of mine who were involved in the gay civil rights movement in Houston when I was active in that movement back in the 1990s, when I lived in Houston and was a young practicing lawyer. And I began asking them what they knew about the background to the case. And what I got from them was basically that I had made the wrong assumption that these two men were even engaged in any sexual activity. And when I heard that, I remember stopping for a moment on the phone and pausing and saying, of course I made that assumption. That is the basis for the entire case. That was the basis for the entire challenge in Lawrence versus Texas. And besides, I said in my naive view back then, that's what the police reported. And they responded that I needed to do a little more research if I wanted to find out what had actually happened. So then I began calling lawyers who were involved in the case, especially the local lawyers who were involved in the case, whom I also knew back from living in Houston in the 90s. And I began asking them what had happened. Had the men actually been engaged in any sexual act? Had the police seen any act if they were? And the response I got from the lawyers was basically, we don't talk about that. And as soon as I heard that, I said to myself, now I have a story. There's something more going on in this case. So I began interviewing people. I ultimately did write a law review article which contains many of the same conclusions, namely that they were not having sex, in my view, and that the police made up a story about them having done so. And then expanded that ultimately into this book. To write this book, I looked at, of course, all of the usual documents one would look at, the charging instrument, the court proceedings as we had them, but I also looked at the participants themselves, and so I went and interviewed the two men who were arrested, Tyron Garner and John Lawrence, and I interviewed the 3 of the 4 police officers who were immediately on the scene and got their versions of what happened, and I'll tell you a bit more about that in a moment. I also interviewed the lawyers on both sides of the case, both for Lambda Legal, which is the national gay rights legal organization that pursued this litigation on behalf of John Lawrence and Tyron Garner, and I interviewed the prosecutors and the Harris County District Attorney's Office, which led the defense of the Texas sodomy law, such as that defense was. Also spoke to 3 judges along the way in the lower Texas courts. I regret to tell you that none of the justices would sit for an interview about this case. So I don't have their perspectives, and what I have to say about the case in this book is limited by the fact that we do not have any of the internal memoranda or access to any of the internal discussions of the Supreme Court. I don't know if we ever will, but we do not have it yet. At least I wasn't able to get my hands on it, or I assure you it would have been in this book as well. So I basically reconstructed the case from the context of the sodomy laws in the United States going back 400 years to the context of the Texas version of a sodomy law, which was refined and narrowed over the years so that it focused very narrowly only on same-sex sexual conduct as of 1973. And also looked at the background of the police officers who were on the scene first that night that the two men were arrested. And of course, I interviewed John Lawrence and Tyron Garner themselves. That's the first part of the book, and I'm happy to talk about any more of that that you might be interested in. The basic conclusion from that portion of the book, though, is that there was a very active, organized civil rights movement for gay men and lesbians in Houston by the time these men were arrested. It was waiting for an arrest of this sort under the Texas homosexual conduct law to perhaps challenge that law on constitutional grounds, but it had not gotten a case yet. There had been attempts to challenge the Texas law in the courts, and those had all failed, basically for lack of standing and because of the Supreme Court's refusal to consider such arguments in a case called Bowers versus Hardwick, decided in 1986. And there were attempts to change the law to have it repealed in the Texas legislature, which were entirely unsuccessful. The Texas legislature treated the attempts to repeal this law in a very high-handed or heavy-handed fashion, basically laughing at the legislators who proposed any repeal, making light of their proposal and rejecting these efforts almost completely, often without even any kind of a hearing. So all of that had been unsuccessful, but this movement had coalesced to try to resist this law. And that movement was ultimately in place, ready to go, when the occasion arose, as it did. So in some ways, Lawrence versus Texas, for reasons I'll point out in a moment, was an accident. It occurs because of a series of serendipitous events, of chance occurrences, of people arriving at just the right time, of prosecutors themselves behaving in just the right way to keep the case alive. But in other ways, this case was an accident waiting to happen. It was an accident for which the gay civil rights movement in Houston was prepared. In this background section also, by the way, I did some research on the Harris County Sheriff's Office, which is the police department responsible for arresting these two men who were outside the incorporated limits of the city of Houston. So the Houston Police Department was not involved. Those two departments, it turns out, were very different. The Houston Police Department was trained in sensitivity to the gay and lesbian community, trained that when you go into someone's home, when you encounter a person you think to be gay on the streets, you don't call them by names, you don't refer to them with anti-gay epithets, you treat them with respect. The Harris County Sheriff's Office, on the other hand, refused to train its officers to have any sensitivity to the basic dignity of gay men and lesbians that they encountered over the years, and refused to have a non-discrimination policy guaranteeing that people would not be discriminated against on the job. And no surprise, there were no openly gay sheriff's deputies in the Harris County Sheriff's Department. It was a very unfriendly place to gay people. It also turns out to have been a very unfriendly place to women, and it turns out to have been a very unfriendly place to racial minorities, including blacks. It had been subject to a number of complaints and lawsuits over the years. So that's the department that produces the deputies that arrive at John Lawrence's apartment in September of 1998. So on September 17th, 1998, which, by the way, is Constitution Day, of all things, the three men, John Lawrence and Tyron Garner and Robert Eubanks, had gotten together to move around some furniture and were at John Lawrence's apartment. Robert Eubanks and Tyron Garner were, at the time, partners. And neither one of them had been involved with John Lawrence. They were simply friends that met occasionally. Robert Eubanks and Tyron Garner had no steady jobs, no steady employment, no car, no place to live. They moved from house to house, from apartment to apartment, from family member to family member. John Lawrence was a medical technician, not especially successful, but he was employed and lived in this working class neighborhood in East Houston. So they get together. They begin drinking after they have moved the furniture for the day to relax. And according to them, at some point, Robert Eubanks, who had a history of heavy drinking, became apparently jealous that his partner, Tyron Garner, who may have been flirting with John Lawrence, we don't know, but he became upset and got some change out of the kitchen drawer and announced that he was going down to a vending machine on the first floor of the apartment building to get a Coke, and he would be right back. Well, he did not go down to get a Coke. He went down with the change and instead put the money into the pay telephone, which was right next to the vending machine, and called the Harris County Sheriff's Office. He called the Harris County Sheriff's Office apparently in an effort to get his partner, who was black, Tyron Garner, in trouble with the police. So what he reported is that Tyron Garner, a black man, according to the Sheriff's Department, this is what was reported to the officers, was going crazy with a gun inside the apartment. Now, there was no gun, there was no rifle, there was no weapon in the apartment. He made this up, but in his intoxicated state, he must have not thought through the consequences that the police would arrive, find that there was no weapons disturbance, and that he, in fact, would be the one in trouble. So he makes this call. Now, this is a high priority call for any law enforcement agency. It is a potentially very dangerous situation. It's filled with anxiety. It is dangerous for the police officers involved. It's dangerous for any citizens that they encounter who they believe may be armed and threatening people. So the police start arriving within minutes of this dispatch having been received, and a couple of them are patrolling just a few blocks away from the apartment. The first officer on the scene was an officer named Joseph Quinn, and under standard operating procedures in the Harris County Sheriff's Office, as the first officer to arrive, he was what is called the priority unit. He makes the basic decision about whether charges will be filed in a given situation, whether people will be taken to jail. All of those discretionary acts are under his control. 3 other officers arrive soon after him. Now, it was extraordinarily fortuitous for the gay civil rights movement that Joseph Quinn was the first officer to arrive. And it was fortuitous because Joseph Quinn, when I interviewed him, told me that he had the largest citizen complaint file in the entire Harris County Sheriff's Office. He almost boasted of this. Now, he disputed the claims and said that they were meritless and so forth, but it so concerned the Harris County Sheriff's Office that he had been sent back to work in the prison, which is terrible for a deputy who's been on patrol, and he had been sent to something that I didn't even know existed for deputies before I began research on this book. He was sent to anger management school by the Harris County Sheriff's Office. And there are a number of stories that I recount in the book involving him and really stern enforcement of the law as he saw it. So he's the first one to arrive. He's the priority unit. They encounter Robert Eubanks, who's standing at the base of, on the first floor, the base of the stairs to John Lawrence's apartment. He's shaking and crying, clearly very agitated, clearly very upset, and he points the deputies up to the apartment. Now their guns are drawn, and they go up one after another, the four of them, up these stairs to the landing at the top. They knock on the door. It was slightly ajar, and this has the effect of opening the door. This is what they told me. And according to the police, they walked in and immediately saw a living room area in this rather small two-bedroom apartment. Nobody was inside the living room area. There was no television on, there was no radio on, nobody was making a sound, no voices could be heard, and so forth. So not seeing anybody with a gun, they immediately twice shout, Harris County Sheriff's Department, so that anybody in the apartment could hear that they were present. They didn't want to surprise someone and have them just start firing at them if there was, in fact, someone with a gun going crazy in that apartment. No response to this call, they said. Two of them, they said, peeled off to a bedroom that was on the left as they entered the apartment, and two of them went straight ahead toward a kitchen area towards the back of the apartment and just off to the left, where they say they saw a man standing beside a refrigerator talking on the phone. Now, these are two sheriff's deputies who have their guns drawn, and they encounter this man talking on the phone and tell him to put up his hands, which he very quickly did, they said, drops the phone. They search him, make sure he doesn't have a weapon. He's secured in a room. And then they notice that there's another bedroom, according to the police. There's another bedroom with the door open but the light off inside the bedroom. But they can see, you can just kind of make out shadows in the bedroom from the ambient light in the living room. So the two officers, John, Deputy Quinn, and Deputy, I can't remember, Landry Tips, and Lilly. Deputy Lilly and Quinn approach this bedroom door. They've got their guns drawn. Deputy Lilly is at the front, and as he approaches the door, he can see what he said were two men inside the apartment having sex. Now, he reports that they were on the floor having oral sex. Upon seeing this, he lurches back, according to the police, shocked by what he has seen. Whereupon Deputy Quinn, the priority unit on the scene, comes around on his right side and crouches down with his gun pointed straight ahead and shouts, sees the two men, he says engaged in anal sex on the bed, shouts at them and tells them to stop what they're doing and tells John Lawrence to step back from Tyron Garner, which he said they would not do. Guns pointed at them, people shouting at them inside the apartment. They would not stop having sex. Then he says they flipped on the light switch in the room and were told them repeatedly to stop what they were doing, which he said they would not do. And in fact, he says that John Lawrence looked at him eye to eye, turned back around and kept on doing what he was doing, and continued this for well in excess of a minute. Now that is a superhuman feat. For most ordinary mortal human beings, the moment would be over, and you would probably have complied with what the police were ordering you to do. But it does, I think, it's obviously defies common sense to believe this story, but this is the story that the police tell. A story they never told in any court, by the way, because there was never any trial. The deputy simply files a 69-word complaint that night in which he says we walked in and the two men were having anal sex, although the other officer is not sure and thinks it was probably oral sex. Nobody, I think, would have believed that story, but I think Quinn may have thought a story like that would be believed. Now, why would he have thought that? I think he would have thought that because gay men, especially, are seen as hypersexualized, as almost animalistic in their lust, unable to control themselves, to control their passions. They lack what Deputy Quinn called self-dignity. They do not have the common decency to stop what they were doing in front of strangers inside the bedroom. So this is the story that he's told. Now, I asked John Lawrence and Tyron Garner about this in interviews that I did with them in 2005. And when I got to the part where I asked them what happened when the police came in, I had a local Houston attorney there acting almost as opposing counsel at the interview, directing them not to respond to questions about what was going on inside the apartment. I nevertheless was able to piece together that I thought the police story was incorrect and made that conclusion. It was backed up by an interview, a final interview I got to do with John Lawrence in April, just about a year ago now, April of 2011. John Lawrence contacted me through the attorney. He was not doing well, and he wanted it finally to be known what had happened in the apartment that night. When I sat down with him, this is what he told me. The police did indeed come to the top of the landing. They had the guns drawn. They opened the door, and I was laying on the couch, said John Lawrence, and Tyron was towards the back in the kitchen at the far end of the dining room table. We were as much as 15 feet apart. We were not having sex, and the police told bald-faced lies. And once they came into that apartment, he said, they noticed some erotic sketches that were on the walls and other indications that the men were gay, and began calling them names, queer and fag and so on, the kinds of things that we heard on playgrounds and everywhere else, and in worse ways. And he says that he did not take that kindly, that he responded by calling the police jackbooted thugs and stormtroopers and similar names, and threatened to contact his lawyer. Although he did not have a lawyer at the time, he would soon have a lawyer. And the police, in turn, did not react to that very well. So the situation very quickly escalated. By the end of it, Joseph Quinn had two choices to make. He first of all had the choice whether to cite the men for having what he said he saw, which was sex in violation of the homosexual conduct law in Texas. That was a Class C misdemeanor, meaning that it was a $200 fine, the equivalent of a speeding ticket or a traffic violation in the state of Texas. And as anybody knows who's ever gotten a warning, not that I ever have, police don't always ticket you in those situations, and he had the discretion not to do so. He had a second moment of discretion, which is having cited the men. Since this was not an offense punishable by prison, he could simply have given them the citation, the traffic ticket, and let it be. But that wasn't good enough for Joseph Quinn. He not only decided to issue the citation to the men for violating the homosexual conduct law, but he decided to take them to jail. And in fact, as all agree, John Lawrence was dragged down the stairs of his apartment, clad only in his underwear, while his neighbors watched. And they were taken off to jail for the night. They pled not guilty the next morning in front of a judge before they had any contact with anybody involved with the gay civil rights movement. And there, I believe, the case would have rested. Because there is no automatic sodomy arrest alert that goes out to gay activists when someone is arrested for violation of this homosexual conduct law. It was not obvious that this arrest would ever be known. But it just so happened that John Lawrence lived in the jurisdiction of a justice of the peace, who's the judge who handles this sort of Class C misdemeanor case. A justice of the peace, who doesn't even have to be a lawyer in Texas, by the way, who had a file clerk who was a closeted gay man. And that file clerk saw the arrest report and the charge of homosexual conduct, and while he wasn't involved in the gay rights movement in any way, as neither were John Lawrence nor Tyron Garner, he thought this was highly unusual. He saw Joseph Quinn's name as the arresting officer, and he knew there probably was something unusual, very unusual about this arrest. And he called his partner of, at that point, more than 10 years. His partner, it turns out, was a closeted sheriff's deputy in the Harris County Sheriff's Office, who also had worked beside Joseph Quinn and knew the arresting officers involved. So that night, the day after this arrest occurs and John Lawrence and Tyron Garner spent the night in jail and then come back home, nothing is happening on this case. They haven't contacted anybody. Nobody knows about it yet. These two men happened to go to a gay bar, which they went to about once a week, and start gossiping with a bartender at the bar. And they mention that this arrest has occurred. And as soon as the bartender hears that, his eyes open wide, because he knows how rare it is to have these sodomy laws enforced against private consensual sexual activity between two adults. All of the other cases had involved some element of force or children involved or some public location. This was an exceedingly rare set of circumstances to have an enforcement, and immediately saw it as a potential constitutional case. And that's how this arrest gets into the hands of first local gay rights attorneys, and then beyond that to Land Illegal. So that leads into the third part of the book, which is the story of how this case went from this justice of the peace court to ultimately to the Supreme Court. And I don't want to reveal everything because I want you to buy the book. But I will tell you a couple of things about it. One of them is that the strategies used by each side, the Harris County District Attorney's Office in defending the law and Land Illegal in attacking the law, were like night and day. The way they approached the case were very, very different, both in the level of talent and attention they gave to the case and in the sophistication of the arguments that they used. Land Illegal and allied attorneys and law professors around the country had been preparing for this kind of case for at least a generation, since the Supreme Court had turned down the last attempt at a sodomy law challenge in Bowers versus Hardwick. They were quite ready for this, and they had honed their arguments to a point that they knew exactly what they were going to say. And what they were going to say was that a law like this violated the Equal Protection Clause and that it treated gay people and straight people differently. It allowed straight people to have as much sodomy as they wanted in the privacy of their homes, but prohibited gay people, same-sex couples, from doing so. And in fact, by the way, Texas in 1973, as it was criminalizing same-sex sexual conduct in all of its wisdom and upholding its great moral traditions, had not only allowed heterosexual sodomy, but had decided to decriminalize adultery, decriminalize a crime that used to be called seduction on promise of marriage, and, not to be forgotten, Texas decriminalized bestiality. So in Texas, it was possible legally for a person to look with longing upon Fido, but not upon another person to whom he or she had been committed for an entire lifetime. That's the statement that Texas made in its criminal law. So they argued it violated the Equal Protection Clause. To do that, you had to have a good reason other than just, we want it this way. The second violation, according to them, was a due process violation, substantive due process, that there was a fundamental right to privacy that had been protected in a number of the court's decisions, and that the court, in fact, had gotten it wrong in Bowers versus Hardwick when they rejected the claim to a right to privacy as applied to the Georgia sodomy law. And those are the two arguments they went with. They hired the best possible talent. They had amicus briefs filed by a range of organizations dealing with history, correcting the history that had been present in the Bowers versus Hardwick decision, dealing with professional mental health and other associations, dealing with our changed understanding of sexual orientation, a more sophisticated view that we now had, dealing with perspective of women's rights, of libertarian groups, of Republican groups that were opposed to the Texas sodomy law. That's on, and they hire at the end of the day Paul Smith, one of the most accomplished Supreme Court advocates in the country, although not on issues of gay rights. On the other side, the Harris County District Attorney's Office entrusted the defense basically to one quite able appellate advocate, Bill Delmore, who had no experience in these constitutional law issues whatsoever, and in fact did not want help from outside sources. In fact, he was embarrassed by some of the arguments that some of the religious conservative organizations were making. Arguments that relied on completely incorrect and baseless arguments from public health, for example. And he decided at the end of the day that the only defense of the law would be to say that Texas and Texans had an interest in promoting morality, and that they were entitled to pass a law of this kind as a promotion of morality. Now that fit oddly, of course, with the fact that Texas was on the very leading edge of the sexual revolution when it came to other sexual acts. But it was enough, he said, for the defense of this law, and the legislature should be entitled to deference. That was basically the argument. At the end of the day, the man who argues this case for Texas is the elected Harris County District Attorney, who had never argued in front of the Supreme Court. In fact, I think there's some reason to believe he had never argued an appeal. So if you take away one lesson from my presentation today, I hope it's that when you make your debut in court, it should not be in front of the 9 justices. The New York Times the next day, after the oral argument in the case, which itself was full, as you can imagine, with double entendres and unintended meanings and so forth, in front of a very sophisticated audience that was seeing layers of meaning in all of the language that was being used. The New York Times called the oral argument a mismatch of proportions that had rarely been seen in the Supreme Court. So what happened between Bowers versus Hardwick when the Supreme Court rejected these claims, calling them at best facetious, and Lawrence versus Texas when the court ultimately strikes down these sodomy laws? I think you could describe what happened in a couple of ways. One of them is that certainly there had been a doctrinal change and a change in the historiography, understanding of the history of sodomy laws, such that sodomy laws did not, in fact, as in the form of the Texas law at least, did not have ancient roots. They were not aimed at homosexuals on their face. They were aimed at all non-procreative, non-marital acts, and only Texas had chosen in a novel way to focus solely on same-sex acts. There had been a couple of important decisions, an abortion decision, Casey, and a decision involving striking down Colorado's Amendment 2, which had stripped gays and lesbians in that state by state constitutional amendment of all civil rights protections in every area of the law. So that had changed. The legal constitutional framework had changed, but something I think deeper had changed that explains the difference in the outcome in these 2 cases. And it's encapsulated by 2 different stories. One from the Supreme Court in 1986, and one from the Supreme Court in 2003. In 1986, after the arguments had been brought, the justices retired to their chambers to consider how they would vote, and at first, at least, had decided to strike down in that case, a Georgia sodomy law, by a 5-4 vote, with the swing vote being a Southern justice named Lewis Powell. But Lewis Powell was unsure of how he would vote, so he brought a clerk into his office and sat him down and said, I'm having a tough time with this case, but one of the things I'm having a tough time with is the fact that I just don't understand these homosexuals. I have never met a homosexual, said Justice Powell to this clerk. Well, in fact, the clerk that he was speaking to was a closeted gay man. And when Justice Powell said this, the clerk debated internally whether he should come out to Justice Powell and whether that might make a difference. It's a huge burden for one person to have to bear. He ultimately decided not to do so. And one never knows whether it would have made a difference. Probably not, but one never knows. And it was a moment that really haunted the gay civil rights movement for a generation afterwards. Because Bowers was then used to discriminate against gay men and lesbians throughout the law. Not just in sexual conduct, but in jobs and in housing, every area of the law. And it was used as an excuse to deny people any kind of civil rights protection, to keep openly gay people out of the military, certainly keep them from marriage and so forth. So that's one moment. Justice Powell says to this clerk, I've never met a gay person. Now, on the other end of this story, we have another incident that I think bookends this case and the change that had occurred. And that is that just before Paul Smith is getting up to talk to the Supreme Court, to present his argument in this historic case where the hopes of all of these advocates are almost propelling him forward, someone whispers in his ear that Justice O'Connor had recently sent to her former clerk and her clerk's same-sex lesbian partner a baby shower gift. So it was impossible in 2003 for a justice on the Supreme Court to say, I've never met a gay person. They were now sending them baby shower gifts. The court saw gays and lesbians not just as people who have unbridled, uncontrollable sex, but as people who have relationships, as people who have families. This was very much a part of the deliberate strategy of the advocates in Land Illegal to show the connections that the court had so glaringly failed to see in 1986, and that's ultimately what they were able to do. So, just to close with one thought, and that is, suppose I'm right that these two men were not having sex and that the police made up a story. What does that say? Does that have any impact? Does it have any importance? On one level, I think it absolutely does not. That is, that the Supreme Court's opinion would not, should not have come out differently because the facts as alleged by the police and uncontested by the attorneys for Lawrence and Garner had allowed this to proceed. So in that sense, it makes no difference in terms of the way the court should have come out in this case, or whether the case could proceed. They had, after all, been arrested, whether they were actually doing anything or not. So does it have any meaning other than for just historians who kind of want to know what happened and want to make sure the story gets set, so to speak, straight? I think it does. And it's not something I would call narrowly constitutional or legal. It's a little bit, to me, deeper than that. If I'm right, and if John Lawrence is right in saying that the police told bald-faced lies about what happened that night, then 4 police officers walked into a private home and arrested 2 men for nothing, for doing nothing in their own home. These sodomy laws were never about prohibiting people from engaging in any specified sexual conduct. These sodomy laws were about attaching a stigma and a presumptive criminal status to an entire group of people. While on their face, the law said it is prohibited to do certain things, in its effect, in the way that the law operated in the lives of real people, by the time you get into an apartment in East Harris County, Texas, these are laws that make it illegal to be, that is, to be gay, to be found in the state of being gay in Texas or really anywhere else, since these laws were part of the cultural background as long as they stood. That's the ultimate significance, I think, in some ways of both the background of this case and what Lawrence versus Texas accomplishes. It removes that presumptive legal status, which affects way beyond what anyone can do in the privacy of their bedrooms. It has effects throughout their lives. And we'll see just how far those effects go in the future. Thank you very much.